Hi, everyone. Welcome to our Facebook live broadcast. I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Family Law. Today, we're here with attorney Darin Wisehart to talk about what you need to know about bankruptcy and divorce, how they interact and impact each other. Hey, good morning, Darin. How you doing today?
I'm great. I'm great. How you doing?
I'm doing well. So, before we start, Ed, can you just tell us a little bit about yourself?
So I'm an attorney that's been doing bankruptcy law for the better part of my career, for about 12 years, and I've been kind of handling different types of bankruptcies, Chapter 7, Chapter 13s, a little bit of consumer issues as well. So kind of throwing back and forth between all of the things that deal with bankruptcy and consumer law and those types of claims.
Oh, perfect person for this job. So, bankruptcy, divorce, how they interact. Can you start by giving us a little primer maybe on what a bankruptcy actually is and maybe the most common types of bankruptcy that spouses or maybe even ex-spouses might typically be looking at?
Sure. So bankruptcy is the ability to not have an obligation to pay debts in the future, and it's got this trade-off that is kind of on a bigger picture idea of you take the debts that you have. You can pay off, if you can pay off some of them, you use a disposable income scale to determine what's going to be paid off, what's going to be payable, and you have to qualify for different types. So we'll talk the two main types that we always talk about, Chapter 7 and Chapter 13. And what we're talking about with the Chapter 7, it's usually a shorter case. It's usually a 3 to 4 months if all goes smoothly. It's the type of case that it's designed to allow you to kind of ride through with your normal items. You have to have exemptions to cover things. So exemptions, we think of those as the umbrella that covers your items. So if you have normal household goods, normal clothes, normal jewelry, usually you'll be able to keep those without any worry of anybody taking those. Now, when you file a case, you're assigned a case number, and the trustee is the person, that middle person, that kind of reviews your situation, reviews your documents, make sure everything's in order. And they're the ones that are going to look at everything to see if there is anything to liquidate. And so the Chapter 7 is called a liquidation because if you do have something that's above, that's valued more than what exemption you can cover it with, then the idea with bankruptcy is that you're going to pay back on that amount or you're going to lose the item. And that's why it's called a liquidation. That's why it's important to know that going into it, because if you do have an item there, then the trustee can take it. And with Chapter 7, you don't get to get out. Once you file, you're in. You can't say, oh, wait a second, I want out of this thing. You can't do that. So it's important, to think about that as you get in, before you go through the door. And with that Chapter 7, it's a good tool to get rid of your credit card debt and your medical debt that have kind of been lingering and collecting. Maybe they're garnishing wherever they are in the process. It's the trade-off of making sure that if you have assets that are above exemptions, you might lose those or you might have to repay those, but it gives you the ability then to zero out those debts at the end of the case, move on with what they call the fresh start, and that allows you then to open the doors on other, get that credit cleanup going and get moving forward without having to worry about that debt chasing you for the next however many years. And so that's your common Chapter 7.
Yeah.
So when we talk to Chapter 13, we talk the other path, and the Chapter 13 is a different. It's got a lot of the same pieces, but it's a different animal. It's designed then to kind of stretch out what you have to pay, and it's also used when you can't qualify for a Chapter 7. So let's say your income is too high, and as a household you don't have enough. So in order to qualify for the 7, the skinny of that is your household size is judged against the income that comes into the house, and you have to be at or under the median income of a household your size in your county. And so of course that's a lot of jargon that I don't want to throw out too much, but it really is the scale of what puts you in a 7 and 13. And there are other exceptions. So there's a lot of little pieces to talk about there too. I'm not covering everything. This is more broad picture. But the Chapter 13, then some of the people who have higher income go to a Chapter 13, and that's called a reorganization. That allows you then to pay over time the debts that wouldn't be taken care of in a Chapter 7, or to pay your disposable income, which is kind of the number that the court deems as fair for you to repay. Now, the beauty of that is your attorney and yourself are going to create your budget. You're going to come up with a number that you have left over at the end of the month. And so that amount is supposed to be what your disposable income is. And that's what you're supposed to pay towards the bankruptcy on the first number, which is what can you pay. And when you do that, then if you get to the end of the case and that's all you do, you just pay what can you pay and that's all you need, then at the end of the case, whatever's left over is zeroed out. And that's the trade-off for being able to file that Chapter 7 reorganization and getting through the process, maybe not paying 100% of the creditors, maybe you only paid 30%, or in a lot of my cases for 5%, 10%. You're not paying too much, but you're getting through that 3 to 5 year span. And then at the end of it, you get what they call the discharge, which is the zero out of these debts. And that's what you're looking for.
That's a great foundation to start this conversation. Getting to the divorce and creditors. I mean, why do we need a bankruptcy? I mean, if my debts are split up in a divorce and my ex-spouse has to pay them all, aren't I already off the hook?
Well,
I think the answer is no.
Yes, the answer is certainly no, certainly no. So when you have a debt, if both people are on the debt or you're in a community property state, you have a debt that both of you can then be collected on. Okay, so the creditors have their hooks in you. Okay, and now you go through a family law. Let's say you go through a divorce. You get that divorce decree, and the judge in their really nice clothes, they're up there and they're looking all official, and they say, okay, this person has to pay those debts, and the other person is saying, great, I don't have to pay those debts. I can wash my hands of those debts, and I'll move on with my life. The problem with that is the creditors, they don't really care what the judge said. Okay, so their agreement with you was signed well before this judge made a determination, and this judge can't alter that agreement. And so what happens is the creditor then, they go collect and they ask questions later, and they can collect on either one of the people that are on the debt. They don't really have to care what the divorce decree says. And so what we always get the call from the individual who's saying, well, wait a second, why am I getting collected on by this creditor? It says in my divorce decree that person's supposed to pay for it. And the creditor, it's not their job to think about that. They have your name on it, and that means they can come after you for 100%. Now, if they come after you and they collect the money, then you have a cause of action against that other person, because you do have an order signed by a judge that says that they're supposed to pay for it. So you can go, you can talk to your family law attorney and you can go after them to get that money back if you maybe contempt or whatever you happen to do to go after them. But the creditor, their job is not to figure that out. Their job is to take money and ask questions later.
Got it. So let's then move on to one of the topics I hear a lot, and it's people who are asking, there's support obligations. Can I get rid of that by filing a bankruptcy, 7 or 13?
Yeah, the straight answer on that is it's been tried many, many, many times, and it doesn't happen. It doesn't work, because there's an exception to discharge for domestic support obligations, and that is alimony and spousal support, child support, all the things that fall under that. And it can even be considered attorney's fees to get that child support, spousal support, all that opposing attorney fees as well. So there's a big ball of items that you cannot take care of. You can't zero out. And we're talking about discharge or zeroing out the debts is what we're talking about here. Chapter 7 or Chapter 13 does not help do that. It won't get you free of those fees. Now, it is important to remember that a Chapter 13 can help if you're behind. So if you need to catch up in those debts, then you can file a Chapter 13, and it's important to talk through what that means and how that can play out if you need to catch up those amounts. But to answer the question just clear, the domestic support obligation is likely not going anywhere. And it's one of those that's going to be around when the case finishes. It's called an exception to discharge, and there's a whole section on this that, as a bankruptcy attorney, we look at pretty often.
So then what about the joint debts? We talked a little bit about from the creditor, but going into bankruptcy with joint debts, how does that work?
So if you go into bankruptcy with a joint debt, then the idea is, and now we're kind of getting into that a little bit of that question of whether it's good to file before or after. And we'll touch on that a little bit more, I think, with the later part of this. But with a joint debt, you go into a bankruptcy, and the idea is if both of you have filed the case, then both of you have shared the cost, which is always cheaper, and you've shared the court fee, which means you only have to pay one time. If you're married, legally married, you can file together. And then the idea is to then zero out these joint debts. And for both people, then you get a chance to zero them out. Now, if one person, and in Oregon, in some states across the United States, they're allowed to file individually. So where I practice typically in Oregon, you're allowed to file with one person, and the partner does not have to file. And so what that means is if you file and you zero out for this debt that you're on the hook for, then the other person is still on the hook for that debt 100%. And so if you zero out, they call you, they're violating the rules, because now they're trying to collect on somebody that's gone through bankruptcy. And that's a violation of the automatic stay or the discharge, depending on when they called. But if the other person is still on the hook for that debt, then that creditor can go after, just turn their sights to this other person and say, I'm going to go after that person.
So if I, shoe on the other foot, if I'm the person who has the debt, the joint debt that I'm supposed to pay, and I go into bankruptcy, does that mean that I don't have to worry about the judge in the divorce court coming back after me for not paying what I was supposed to pay?
We'd like to think that. And that's one of those ideas with the bankruptcy. The idea with bankruptcy is to give you that fresh start. And bankruptcy really seeks to give you the fresh start wherever they can. But in this case, they've decided to cut out an exception for that discharge. And that is to allow the judge then to come after you for contempt of the order. And it's definitely an area that you want to speak with an attorney if you have that situation, because they can get very complex. They can get very long and drawn out, of course, with contentiousness, especially, with the fighting that can go on sometimes in divorces. But you want to make sure you speak with an attorney about those specifically, because there are angles on both sides, and you see creative attorneys try to tackle that. But at the same time, the idea with it is that there's a carve out, and there's the idea that you're in contempt of this order that this judge signed in your family law issue, and it may supersede that issue in bankruptcy.
So I can't get out of my spousal support or my child support by filing a bankruptcy, it sounds like. But let's say we have a property settlement. And part of the property settlement, because everything isn't always equal, a house is more than a bank account or a pension or something. And I end up having a judgment. I got to pay my spouse $50,000 to equal it all out. And then I go bankrupt. Well, I can get rid of that, can't I?
Property settlements are one of those. And here's the thing. I always say with these, and you always want to look at every specific case, because every case could have something a little bit different. And every one of these has one element that's different. And in the property settlement, the Chapter 13 may be able to take care of a property settlement debt. And that's one of the only ones that has that carve out. Now, if it's considered a domestic support obligation by any judge, then it's going to come back under that window of, this is a domestic support obligation and it's not going to zero out. But there is a chance with Chapter 13 that you can take a look at a property settlement, and it's a complex area. We could do an entirely new class on that one, a new Facebook Live on that one, just particularly because if you have that, you need to speak with an attorney as soon as you can.
So if that makes complete sense. I mean, it sounds like there's laws both in the bankruptcy court and in the divorce court that are going to be either dealing together with this or maybe at odds at some point. So, I mean, it almost feels like there's two layers of law that, kind of rule in this thing.
There certainly is, and there's always that interplay between state law, which is your county courts, and federal law, which is the kind of the United States idea. And bankruptcy is federal law. Bankruptcy is all the United States. And so when we look at bankruptcy, if I move to another state, if I work in another state, the general idea, the code is going to be the same, and it's always going to be the same. The local rules might change a little bit by area, and then in different circuits, I mean, First Circuit, Ninth Circuit, there's the different appeals court areas, and the laws will change for those areas. And then of course, the Supreme Court says it's good for everybody, right? So that's how the federal will look with bankruptcy. And they'll have interplay with the state courts because they allow exceptions. A lot of states allow exemptions for the different states to come in and be those exemptions and allow you then to use their state exemptions to protect your items. And in our state, in Oregon, you can use both. You can use the federal and the state. And so you get a choice when you start. And that allows you then to look at your items. In California, they have two lines of state exemptions that they can use. One protects your house larger, and one protects your items if you don't have a house, and it puts more money towards that. So there's the interplay that always happens between the state and the federal, and the federal, the bankruptcy courts, they like to defer to the state for different rules. And family law is one of those areas where they try to apply your own state's laws as they go through it, so that they don't just walk all over your laws and say, hey, we know what happened here, but we don't care. We're going to do whatever we want. The federal tries to kind of dance around it and be nice about, hey, we want to make sure that if you have a family law judgment, you have a divorce decree, something like that, we want to give that credence, even if you get through bankruptcy. We don't want to just zero it out because that's not the right way to do it.
That kind of leads to a section that we had been talking about, that it's a big question, and it's that sort of, when do I file for bankruptcy? What kind of a bankruptcy do I file? And for instance, I come into you and I'd say, well, I've got child support I'm behind on, and they're about to come throw me in jail. I got spouse support I'm behind on. What the heck do I do? Does that
Go ahead, sorry.
Does that kind of fit into, is one bankruptcy better than another? And is timing an issue and all that kind of stuff?
Yeah, with that particular scenario, timing is not quite as much of an issue because you want to get filed as soon as you can. Because likely, if you're behind on child support, likely the state's sinking their teeth into you. They're usually garnishing. They're doing what they can. And of course, your ex-spouse, they want to start payments. They want to get payments going as soon as they can too. So they want to get you on a path that gets money into their budget. And I mean, it's in everybody's interest to try to get filed as soon as you can. Now, of course, I always say, fast is not necessarily rushed. So at the same time, we want to think about whether or not it's the right move for you. We want to make sure that all the other little pieces are going to fall into place. And we want to know what's going to happen with everything, because bankruptcy is not just one thing. You can't call and say, hey, Darin, I want to catch up with this one thing. I want to catch up with my spousal support, and I don't want my house or my car or my house in Hawaii. I don't want any of that stuff affected. And so then you think, well, that's not how bankruptcy works. Bankruptcy is an all or nothing. So when we file, we want to know how it affects these other things. But talking specifically to the question, if you're behind on spousal support or child support, a Chapter 13 is your way to go. Now, that's the longer one. That's the one that allows payments over 3 to 5 years. You don't want to do a 7, because a Chapter 7 really is not going to catch you up any. It's just going to get rid of the rest of the stuff, which could help. It could help to get those other creditors off your back and then free up some money in your budget to allow you then to divert money to catching up that spousal support or the child support. And so it does have some positive there, but typically we look at both of those. And the Chapter 13 then allows the catch up, which was what they call the cure. And the cure is what allows payments over time. So the idea is, once you file, let's say we file today, and everything that I owed in the past, if I still owe that child support, spousal support, it's stuck into a category, and I got to repay that by the time I finish my chapter 13. And so it'll get paid, and we usually will do an equal monthly payments. Now you can be creative with how you do the payments, but typically you just say, okay, let's get a budget together. Let's figure out how much you can pay monthly, and let's make sure that you can make that payment to catch up that amount over up to 5 years. And you get up to 5 years to pay it off. That catches it up. And then you have to make sure that once you file, that you're making your normal spousal support or child support payments after the filing date, because that's required. You have to keep current. And that allows you then at the end of the thing, at the end of the 3 to 5 years, however long you have to go, you're cured. You're caught up, you're done. It also, the gigantic one is on the day that you file, carrying all the way back to our filing date, which would be theoretically today, it allows you to stop a garnishment that's happening. That's, the state sinking their teeth into your paycheck every pay period and making it tough for you to make those normal bills. And it really gets you a chance to kind of take control over that budget. And you still have to hit the number. It still has to be, it's still tough for some people, but you're going to have control over how the budget is created. And then what do you have to pay? What do we need to pay to get this thing finished and done successfully?
I have two questions on that, I guess. First, well, if the 5 years are up and I'm struggling and I'm not going to make it, can I just file another one?
Interesting question. And yes, you can, because, well, there's a few different things that you'll do. So first, you'll be communicating with your attorney over the course of that. And the idea with bankruptcy with Chapter 13 is that your attorney's fees will get paid over time through your bankruptcy plan. And so you'll be communicating that, and hopefully you'll see the writing on the wall well before that in the 60th month comes. Because if you're there, you're kind of too late. You've closed some of the doors that you may have had open, but you're going to analyze that over the course of the case. And then say you're getting behind again, maybe your budget's just not allowing, maybe you get laid off, maybe something happened. 5 years is a long time, so things can happen. Maybe you move to another state, who knows? If that happens, you're going to communicate that with your attorney, and you're going to figure out how you can either make the payments, and then of course, you can always, in Chapter 13, it has a gigantic card that people can play, and it is, I have the ability to dismiss at any time. And that allows you then, if you're off path, if you get off path, for whatever reason, you can look at whether it's in your interest to dismiss the case, and then you can start a new case to try to do it again when the situation is the right. And at that point, you're very well versed on what you're supposed to do. So then everybody can get in the boat very educated on how they're going and know, can we do it or can we not? And sometimes you happen where you get towards the end of the case and you think, there's still $8,000 left to pay. We can't pay it. So how about we just dismiss this one, or we allow this one to discharge to finish successfully if we can. And then we get rid of, that unsecured debt, the credit cards, the medical, all that stuff. And then we can file a new Chapter 13, not looking for a discharge of any debt, but just looking to then spread that payment out. And we sometimes call that a Chapter 20 when we talk about putting a Chapter 7 with a Chapter 13, because that Chapter 13 filed after it is not looking for the discharge. We're looking for a discharge in the Chapter 7 to wipe away all the junk, the credit cards and the medical debt and the collections, the personal loans, all that stuff. And then we look at the Chapter 13 then to even out those back child support, back spousal support payments that you need to get the garnishment stopped. Maybe you have taxes that didn't go away with the Chapter 7. Maybe you want to catch up a house or catch up your car payment, all these kinds of things. These are reasons why you might file a Chapter 13 anyway, but you might file a Chapter 13 after you've zeroed out that unsecured debt with the Chapter 7.
Well, that's really interesting to know. So let's move towards the when, because I know you talked about that's a major question that goes into bankruptcies is just, we're thinking, even, we're not doing well, our marriage is not doing well, we're in financial trouble. Do I file now? Do I wait? Do I file during the divorce? I mean, that's not necessarily an easy question, is it?
It is not an easy question. And it really needs the review of an attorney before And I always tell people, I tell this people as many times as I can say it, you want to make sure you get that consultation with an attorney as you're starting to think about these things, because the more doors you can open and keep open, that's the more options that you might have. And in bankruptcy, it's not playing the game, in a way other than just saying, hey, these are the rules and I'm going to play by the rules. I'm going to do what I'm supposed to do. And timing is a gigantic thing when it comes to bankruptcy. In some situations, it's a good idea to file together. A lot of times we might file a Chapter 7 before you look at the family law proceedings. If you can cooperate, of course, you have to be able to get in the boat together, because you have to move together, because your bankruptcy attorney has to represent you together in order to file that joint case. But if you can't, then maybe you file a Chapter 7 separate. But if you do that, like we said before, you're paying attorney's fees for each person, you're paying court fees for each person, and you have a separate case number to get the same goal done. So you really can put them together, and economics say that, paying once rather than twice is a much better idea, right? So when you go through it before, you can Chapter 7, you can write off this debt. And that allows you then, it's a gigantic card to use if you can make it happen. If you qualify for the 7, of course, sometimes it helps you to qualify with the whole family, because maybe you have a member of the family that's not working, or maybe you have all the kids available as dependents, and your household size can be bigger to qualify for 7. And that'll allow you then to qualify for this 7, whereas maybe after you wouldn't. And then it allows you then to get into the process, zero out that unsecured debt, which is your credit card debt, your medical debt, your personal loans, your payday loans, all the stuff that's that little stuff that is going to have to come into play. If you don't get rid of it, it comes into play for the family law proceeding, because then the court has to figure out who's going to be paying that and how is it going to be taken care of. Is it going to be both? Is it going to be that one? Is it going to be this one? And they're going to need to decide that. Well, if you file a 7 together prior to going through the family law proceeding, then nobody has to figure that out, because it's been zeroed out for everybody. So now you have a chance to go through the door of the divorce court and have at your custody issue and your separation of assets and things like that. It also makes it clear for what assets are there. And sometimes I hear attorneys, family law attorneys, if I file the bankruptcy for both of them, I'll hear family law attorneys open up those bankruptcy documents and say, well, here are all the assets listed nice and clean. Everything's truthful and honest. And we know what's here. We know what we have to split. We know what's worth what. We have estimates on values. And it can make it very simplified on the assets and the debt side of your divorce. So it kind of just takes away those big pieces that sometimes are fighting points when you go through the family law issue. As you go through each step, it just takes one of those or two of those variables out of it. And then you can just focus on, the custody issue or the other issues that might still be there.
So when you say file before, do you mean file before you start the divorce, as opposed to file before the divorce is over? Because I imagine that if you get into the middle of a divorce and file, it's got to, if let's say one person files before the divorce, then you get into a divorce, that can kind of upset the apple cart a little bit.
Very much so. I would even say one step further. I would use the old grab the monkey wrench and throw the monkey wrench into it, because that's what you're doing. It gets really complex, because then if one person in the middle, in my mind, you always either want to file before or after. You don't ever want to file in the middle. And I do see it happen. Periodically, I'll see cases where people will file in the middle, and then they have to, so they file, they get the automatic stay. That stops any collection, any process to deal with money. It doesn't stop any criminal events. It doesn't stop any, technically it doesn't stop the family law for the custody or any of that. But usually the smart attorney will then say, okay, well, we got to put a pause on this. We got to go to the bankruptcy court to go before the judge and ask the judge if we can move forward with this family law, with the divorce proceedings. And they will usually do that. And the judge will usually grant it, but it takes time. It takes money on both sides. Then you have to have your attorneys maybe even hire bankruptcy attorneys to figure out how the bankruptcy plays into where you are. I mean, think of it as being in the middle of a river, and all of a sudden, one person wants to jump out temporarily, and then they're going to have to jump back in the river. And now everybody's looking around going, what are we doing? Where are we at? So they'll talk to the judge, they'll get approval, they'll go back, they'll continue, cost extra money for everybody. And really, it's not going to achieve any true goals for the most part. Every once in a while, I see an offshoot reason why it might help. But most of the time, all it does is prolong the event, make it more contentious, and really, it doesn't accomplish very many goals other than pausing your proceedings and costing extra money.
Sounds like there are a lot of pretty good reasons to try to file and complete the bankruptcy before you file for your divorce. What about after? What about waiting to even file for the bankruptcy till the divorce is done? Is there any benefits for that?
Yeah, there are a lot of benefits for that. And that's typically when I look at scenarios, if I have people calling me for this type of question, that's usually where I advise they go. Because usually you have the debts, you're going to have to figure out the debts anyway. And typically if they're calling me before the family law event, they're independent. They're probably not on good communication terms. They're not able to file a case together. There's going to be a lot of reasons. They're a little bit too late to file for a Chapter 7 because they're just too close to a family law event. Whatever's happening is already taking its course with their relationship and with the household. And so I will usually say, well, let the dust settle on your bankruptcy or on your family law event, on your divorce decree, and get to the point where you're finished. You have your assets all cordoned off. You have everything, there. Make sure a judge signs it. It's a big event in bankruptcy. It's a major question from trustees and from the case were both people represented? Was it even, or did you sign something that somebody had all the power? And sometimes trustees at the end of a bankruptcy or at the end of during a bankruptcy after a family law divorce decree or something like that has taken effect, they can undo the divorce decree if it was unbalanced when you guys went through the process. So you want to make sure that you have a good balance on what you're getting and what you're trading off. And if you're both represented, typically it's going to be acceptable because then you're balanced if you're both represented with equal counsel. So you want to look at that. And when you look at a bankruptcy afterwards, first of all, you'd never want to file a Chapter 13 before you went through the divorce because Chapter 13 is 3 to 5 years. And so anytime you talk about somebody who has higher income, somebody who has an asset where they have a lot of equity in their house, they have maybe $100,000 sitting in the bank, things like this, maybe a house in Hawaii, who knows? They're going to want to file a Chapter 13 anyway if they file any bankruptcy. And that bankruptcy then is going to be filed. You're going to want to file that after the family law event. Because if you're looking at a family law, a divorce, you're looking to go into that process, you don't want to be stuck with this person, connected to this person for 3 to 5 years. And that's something that, you would typically advise. And it has its advantages and disadvantages on both sides. You're going to take a little plus and minus. And it comes back to something that I say in bankruptcy all the time. There's always a negative, there's always a positive for things that you do. That's how they design it. And with Chapter 13, you would just file afterwards independently by yourself, just roll forward. Now you're not married, so you can't file anyway together. And with the divorce decree, that'll separate your items. It'll figure out what you need to do with your debts. So of course, back to our question on if the debt is supposed to be paid by you, or if it's supposed to be paid by the other person, it's still going to be on your list. So if you're there, you file a Chapter 13, it's still going to be a creditor. You're still going to want to list them, even though maybe your ex-spouse is supposed to pay it. It's still going to be there, and it has to be there. That's what the code would require. Your name is there, and they can collect on you. So you want to make sure they're included in your bankruptcy.
So let's say my ex-spouse files a Chapter 13 after the divorce.
Mm-hmm.
I realize we can't file a code 13. We're not married anymore. But is there any sort of coordination that goes on if I come into you and say, well, I think I need to file a 13 now because, all the debts are both of ours. Do they coordinate at all or look at each other at all?
interlocking things that happen in two cases where ex-spouses were there, or maybe you choose to do it before and you're just going to push off the divorce for 3 to 5 years and just go through chapter 13s independently. That does happen periodically. There'll be co-cases and they'll be linked. And this happens sometimes when both people are on the home loan, or both people, whatever it happens to be. Maybe you have 2 houses and each person, you have 2 signers on each one of the mortgages, and the mortgage creditors are not going to let the other person off of the mortgage. So one way or another, the other person's going to be included in your bankruptcy because they're going to have to get notice. They're going to be on those debts, and they're going to want to know what you're doing with those debts, because if you walk away from them, you wash your hands of those debts, the other person's going to be on the hook. So everybody's going to want to know, what's going on. If you both happen to file together, you would have kind of sister cases, and you'd have, the trustee would then be looking at those to see who's paying for what are the assets, what are the combined, interests. And of course you won't have the same attorney, because that's just not, that's not something that would happen. But you can definitely have a path that is both of you filing a case after you had the divorce finished.
We're running out of time. I hate this. We're running out of time. This has been really cool, but I do have one last thing that's kind of nitpicking at me, and that is, I work with a lot of professionals who kind of sometimes will say, God, I wish I'd seen the divorce decree before it was signed, just because I could give some input from my point of view as a professional. So if someone comes into you and they're talking about filing, or maybe they're divorced and maybe filing after, do you ever say, well, how you divide your property, how you do your settlement may have effect on your bankruptcy? So, it'd be great if you could, show me before what it's going to be. I could give you some advice on that. Or is that something that's kind of split apart completely?
Well, you can definitely advise both ways. And a lot of times when people come in, talk to me before the family law event has happened, before they file for the divorce, they're going to go get their attorney, or they already have their attorney. I can work with their attorney to kind of review things and make sure that on the bankruptcy side, we're looking where we are. Now, of course, in my practice, I don't like playing the gray area too much. So I'm not going to, if I look at a divorce decree that's going to get to that finalized point, and that's really the main point that I'm going to be concerned with. I want to make sure that it says what's not going to affect our case. And so I'm going to review it. And typically, if it's been battled over, that resting spot is going to be somewhere that's going to be usable for me anyway. It's not going to be too altered. But we do get situations where before that divorce decree has been signed, somebody will come to me and say, okay, we're negotiating this and we're doing a little horse trading here. Should I trade this part or this part? And then I can say, well, absolutely trade that part, because I can protect this part, or because this situation is better for you. So it's always better, costs a little more. I know it's got that kind of added where there's an extra hand in the pocket, and we try to be efficient with how we do it, but it's a necessary spending of money, because it gets my eyes on this thing before it's signed, before it's finalized. And if it can help you save, thousands of dollars, then of course it's worth your money to have happen. And as we look at it, we can all make sure that we're working together. And I won't have my hands too deep on what's going on with the family law thing, but it's good to be able to review it before it's signed, for sure.
Oh, you would imagine. You would imagine. Well, gosh, we are definitely out of time. Thank you so much, Darin, for being here today. It was great insight on bankruptcies, divorces, how they intermingle, how they impact each other. And, at the end of the day, why it's so important to have a good attorney from both areas, because there are separate but also equal kind of issues going on. So thank you very much for today.
Yeah, no problem. Thanks for having me.
You bet. We're gonna look forward to talking to you again, because I imagine there are many issues that can arise that are a Facebook Live in themselves when it comes to bankruptcies and divorce.
Absolutely. I look forward to it.
All right. Well, thank you everyone for joining us today. Anyone who has questions on today's topic, you can post them here. We can get you connected right away with Darin. Until next time, stay safe, stay healthy, stay happy.